Because till they make out a case, and some of them may be saying complete, some of them may be saying less, and therefore it will be better for you if you can.
Just in that the uncitral can also complete against modification, and I leave it to your lordship. I can do that. All right. Number Lord, broadly speaking, without going to this, my submissions are this: that the section 34 has been hastily put into our act. It is not intended for domestic arbitration. In fact, the insertion of subsection 2A by the 2015 amendment itself shows that they requires a separate treatment for domestic arbitration. First point. I'll go to uncitral model and say why 34 is a misfit. Second submission, Lord, is that the power to set aside will include the power to partially set aside. St. Xavier's 9 judges say that the larger power always includes the lesser power. Mohammed Kunni says that if I can do something at the end, I can also do it earlier. So power to set aside includes power to partially set aside.
So section 34 itself provides for.
So 34 doesn't provide for partial set aside. Yes, only the proviso.
The proviso,
yes. Yes, but 34 is in two parts, 34.2a and 34.2b. There are two parts. And lastly, my submission is, I have made a small note, a chart. My suggestion is that if we can add 2 words, 3 words in 34.2b and just 2 words in 34.2a, a lot of the problem can be sorted out in my submission. And I've given at least 8 judgments where Supreme Court has added a word so as to make, so that absurdity doesn't result. And there's a wonderful judgment of the Bombay High Court where a phrase has been added to prevent absurdity in the statute or make the statute unworkable or ineffective. Now, my lord, kindly see the objects and reasons of the act. My lord, I've made that additions also. I'll place it before the court. Now, kindly see the objects and reasons of the act. Lordship will note, my lord, this act intention was to codify and consolidate all the laws regarding arbitration. Earlier, as Justice Viswanathan pointed out, it was scattered. You had the Foreign Awards Act, the Enforcement Act, and the Domestic Act. So the very opening paragraph of the statement of objects and reasons says that everything has to be consolidated. Lordship has got a statement of objects and reasons. The opening part on top says,
there only has the preamble.
Lord, I've got in this book on Universal, there is an introduction.
Yes, it is. Introduction is there below that statement.
Yeah, below that statement of objects and reasons. The law of arbitration in India is at present substantially contained in 3 enactments, namely the Arbitration Act 1940.
Brother, wait. Brothers are
sorry, my apologies. Yes. But I've got the Universal Book of 2024.
We have the same book.
Same. So, Lordship will just take page 1. All your Lordships have got it. Can I read?
After the introduction.
Yes. But introduction is the work of the editor. I'll go by the statutory provision, which is the statement of objects and reasons. The law of arbitration in India is at present substantially contained in 3 enactments, namely the Arbitration Act 1940, the Arbitration Protocol and Convention Act 1937, and the Foreign Awards Recognition and Enforcement Act 1961. It is widely felt that the 1940 Act, which contains a general law of arbitration, has become outdated. The Law Commission of India, several representative bodies of trade industry, and experts in the field of arbitration have proposed amendments to this Act to make it more responsive to contemporary requirements. It is also recognized that for our economic reforms to have not become fully effective, if the law dealing with the settlement of both domestic and international commercial disputes remains out of tune with such reforms, like arbitration, conciliation is also increasing worldwide, is getting increasing worldwide recognition as an instrument for settlement of disputes. There is no general law on the subject in India. Then below para 2 is the UNCITRAL model law. I'll read that. The United Nations Commission on International Trade Law, UNCITRAL, adopted in 1985 the model law on international commercial arbitration. The General Assembly of the United Nations has recommended that all countries give due recognition to the said model law in view of the desirability of uniformity of the law of arbitral procedures and the specific needs of international commercial arbitration practice. UNCITRAL also adopted in 1980 a set of conciliation rules. The General Assembly of the United Nations has recommended the use of these rules in cases where disputes arise in the context of international commercial arbitrations and the parties seek amicable settlement of the dispute by resort to conciliation. An important feature of the model law and rules is that they have harmonized concepts on arbitration and conciliation of different legal systems of the world and thus contain provisions which are designed for universal application. Now, para 3 is extremely important. Though the said UNCITRAL model law and rules are intended to deal with international commercial and conciliation, they could, with appropriate modification, serve as a model for legislation on domestic arbitration and conciliation. Lordship will kindly emphasize on appropriate modification. No modification has been done as far as the Act is concerned. Now, Lordship will kindly have summarized the model law and just two small changes have been made. So, and in fact, the Lok Sabha debates, there is saying that it's done hastily, you're not taken into account all those points. Lok Sabha debates are there. But the fact remains that the objects and reasons said that this is a law meant for international arbitration, where the participants are from two different countries. And that we'll adopt with modification. Now, Lordship will just come to page 93.
Shilata, we will not be able to go into the question because, if I'm not mistaken, when the Act was made, 85 itself led to a lot of debate. Section 85, because there were a number of ordinances and then modifications and then finally passed. Finally, the Act.
No, what happened was the arbitration ordinance came in 1996. In fact, on a personal note, the very first case in India on arbitration ordinance was the Madras High Court where I appeared, and we had this new provision of section 34. That was the first case in India on this.
So 85 itself went in for which one will apply?
1940. After
3 rounds of ordinance repeated, and there were a lot of consultations.
There was a lot of controversy. So don't go on that.
No, I'm on the basis that section
Yeah,
34.
go on the core principle that the the word setting aside the greater power includes the lesser power is a well-known concept. And why do it if it is cut short litigation? After all, the object of legislature can or not mean to say that obvious things cannot be corrected.
Correct.
And obvious mistakes cannot be corrected.
Yes.
And that will not amount to modification of.
I'll get your Lordship's point. What I'm.
Doctor, you may not be right.
Yes.
All international commercial arbitrations are not foreign-seated arbitration.
Pardon me?
All
Correct.
There are India-seated international commercial arbitration.
Yes.
For which part 1 will apply.
Yes.
So it is wrong to say that,
No,
there was
but
no uniformity.
No, the definition of international commercial arbitration is one party is
Abroad.
foreign.
And
So-
if it is seated here,
Huh.
part 1,
Yes.
seated abroad, New York Convention.
Yes.
So part 2.
Yes.
So when they say, though they said UNCITRAL model law and rules are intended to deal with international commercial arbitration and conciliation, they could, with appropriate modifications, serve as a model legislation on domestic arbitration.
Yes.
So
The
it includes one category of international commercial, which part 1 applies.
Yes, true. But the point I'm raising is this difficulty which we have faced for the last 20 years and this kind of continuous confusion on arbitration, resort to Article 142 and so on, is because Article 34 of the UNCITRAL model law is necessarily a pure international arbitration where there are two parties in two different countries. That's the context I wanted to give to Lordship. My Lordship said no need to go into it, but Lordship will just take it from me that 34, which was there in the UNCITRAL model law, is meant for two nation arbitrations. And that's what the explanatory note says in the United Nations itself. Now, what they proposed was they'll take section 34. See, what happened was they're going to make the 96 model law as the basis. If your Lordship sees chapter 3, chapter 4, etc., identical copy, starting of arbitration, terminal proceedings, identical copy of UNCITRAL model law. We come finally to chapter 6, which is recourse against an arbitral award. Then there they put in 34. Now, what they put in 34 is something which can never be contemplated for domestic arbitration. That's why, as the learned solicitor said, many countries who are signatories to UNCITRAL model law they took the trouble of drafting separate domestic arbitration laws. UK, Australia, Canada, Singapore. They are all signatories. But they chose to take a different step. Now the point is we can't judicially legislate. This court can't put a new section like UK. But we can make repairs, small repairs, and as Lord Denning put it, is going to be my final submission. If there is a complete inconsistency and the section is crying, begging for change, we can't wait till the legislature changes it. Your Lordships, in my humble submission, can add just a few words which I have drafted and put it for your Lordship's kind consideration. If you agree with that, in my submission and subject to what my colleagues here say, we can have a particular solution to the problem. Now, today, what is the problem, my Lord? An arbitral award is horribly wrong. Mr. Khambata's case is egregiously bad. He will come to it when his turn comes. It's a dissenting award, 2:1. The majority award is completely contrary to basic principles of law. Completely contrary. The dissenting arbitration is absolutely correct. What is the remedy? Set aside the award. Take another example, my Lord the Chief Justice gave. There are 5 issues. A, B, C, D, E. D is patently wrong. But D is not severable. And that D is wrong not because of the powers of the parties. The tribunal did not made per incuriam, or they completely went egregiously wrong, patent illegality. Though I have succeeded on A, B, C, and E, because of the D, which is like the drop of poison which destroys the whole milk, whole award has to be set aside. Now, the arbitral section 34 doesn't say after set aside, do what? Where is the power to say it will be remanded back?
No, in that case, 43 will come into picture.
42.3 say we'll exclude tribunal. That's
Yes,
only
what
thing
for?
for us.
If the arbitration clause doesn't evaporate, then you can invoke
You
fresh
can invoke,
arbitration.
yes. Now my point is, now the question arises, suppose on the second round, one more illegality is there, what happens?
No, that can be.
I mean, where do you keep
No,
on
no,
going?
that should not be an argument.
No, my Lordship is right.
That should
So,
not be an argument.
I was just saying, my Lord, just see section 34 of the explanatory statement. Why 34 was introduced? Because they said different countries have different laws to set aside an award. We want to bring in uniformity. If your Lordship will just indulge me.
That's correct. You are right on that way,
Yes.
because if you look at the provisions, the way they were, it was, yes, probably,
Chaos, yeah.
it was probably like an international cooperation to have at least a uniform arbitration, international arbitration, something like the New York Convention,
Yes.
which basically primarily based
Yes,
on,
yes.
if you look at the clauses also, they're primarily based.
But then the basic thing is clarity and consistency. The 2 points of international law is clarity, consistency. So everybody knows where they stand. Now, Lordship will kindly see, just come to page 93. Just 2 sections I'll read and I'll proceed further. This is important. Page 93 of the compilation. I've also given soft copy, sorry. Ironically, in 2006, they provide for amending interim award. What about that? Please come to page 93. Article 1(1). This law applies to international commercial arbitration subject to any agreement in force between this state and any other state or states. Now, please come to the definition of court at page 94, Article 2C. Court means a body or organ of the judicial system of a state. Now straight away come to Article 34. And I reproduce all these articles to show that everything has been lifted and put into our article, our Arbitration Act, Section 16, Section 17, 30, 31, 32, 33. And finally, please come to Chapter 7, which is at page 900. Now, 2, 34.2. Lordship has got 34.2. An arbitral award may be set aside by the court specified in Article 6 only. So that has been deleted. May be set aside by the court that specified in Article 6 is cut off in our Act. Only if. Then it goes on. Then B, identical 1, 2, 3, 4, including the proviso, B also. And the last one, B2, the award is in conflict with public policy of this state. It has become of India. Apart from that, there is no change. Now you please come to Article 36. Now, Chapter 7, we make it different. We provide arbitration is final. It will be like a CPC. When you go to Chapter 7, we have redrafted the section. Article 36, grounds for refusing recognition or enforcement. And Lordship will kindly see, it is identical to 34. Now come to page 108 as to why this was necessary. Page 108. Para 44, may I read 108. The disparity, Lordships have got para. The disparity found in national laws as regard the types of recourse against an arbitral award available to the parties presents a major difficulty in harmonizing international arbitration legislation. Some outdated laws on arbitration, by establishing parallel regimes for recourse against arbitral awards or against court decision, provide various types of recourse, various and often long time periods for exercising recourse, and extensive lists of ground on which recourse may be based. Part 2 explanatory note. That situation of considerable concern to those involved in international commercial arbitration is greatly improved by the model law, which provides uniform grounds upon which and clear time periods within which recourse against an arbitral award may be made. Then, my lord, they mention what are the applications. Kindly come to para 46. As a further measure of improvement, the model law lists exhaustively the grounds on which an award may be set aside. This list essentially mirrors that contained in Article 36.1, which is on enforcement, which is taken from Article 5 of the New York Convention. The grounds provided in 34.2 are set out in two categories. Grounds which are to be proven by one party are as follows: lack of capacity, etc. That's to all this is 34.1a, where the applicant has to say what are the grounds to set aside the award. That is 34.1a. Now on page 109, grounds that a court may consider on its own initiative as follows. That is 34.2b, non-arbitrary subject matter of or violation of public policy, which is understood to be a serious departures from fundamental notions of procedural justice. The approach under which grounds for setting aside the award under model law parallel the grounds for refusing recognition of the award under Article 5 is reminiscent of the approach taken in the European Convention on International Commercial Arbitration, 1961. Under Article 9 of the latter convention, the decision of a foreign court to set aside an award for reason other than the one listed in Article 4 does not constitute a ground for enforcement. The model law takes its philosophy one step further by limiting the reasons for setting aside. That's the reason given. Now, I have also reproduced at page 111, because this is the 85 as amended with 2006. And here again, the same point is there. Lordship will just come to page 114. This is from Mr. Chandrasekhar Rao's book, where you get a copy of the 85, original 85. Now, Lordship will just come to page 115. Existing national laws provide a variety of actions or remedies available to a party for attacking the award, often equating, etc., etc. So my submission is the problem now that was created for India was taking section verbatim and putting it into the part relating to domestic arbitration, and that's what creates the problem. Now, please come to the arbitration section 34 itself. 34. Now, my lord, see the amendments that had to be made. One was adding the explanation. But today, my lord, my submissions are confined to domestic arbitrations. Domestic arbitration. So please come to 2A. An arbitral award arising out of arbitrations other than an international commercial arbitration may also be set aside by the court if the court finds that the award is vitiated by patent illegality appearing on the face of the award, provided that an award shall not be set aside merely on the ground of an erroneous application of the law or by reappreciation of evidence. Now, my submission is 2A is itself a recognition that 34 on a standalone basis will not suffice. For domestic arbitrations, they require some element of judicial risk, and Parliament has provided patent illegality appearing on the face of the award. So illegality must be patent, it should not be latent. And the further proviso says you can't set aside merely on the ground of an erroneous application of law or by reappreciation of evidence. Now, under section 34 as it stands, can we read in an inherent power to modify the award? And as all lordships have remarked, the larger power always includes the lesser power. Since Xavier's judgment is there, I can give the para number. Lordship may also note Pepsi Foods where they say the larger power includes the smaller power. Now please see my note, my lord. Page 2. Page 2 of my written submission. I'll quickly run through it so the others can start.
Yes.
Yes. Now, my lord, I have read out, please come to 2.5 and then I'll go to the next paragraph. Several other nations, which were also signatories to the UNCITRAL model law, made separate provisions for domestic awards to be modified, various set aside. For example, section 69 and other sections of the English Arbitration Act, 49 of the Arbitration Act, 2001, etc. I think learned solicitor has given the various examples of other countries. Now, this is the next point I'm making. Section 34 refers to powers to set aside the award. It is a basic principle that a larger power includes a lesser power. This is based on the maxim so-and-so, which means the greater contains the lesser. A bench of 9 judges has also held that the greater power contains lesser power. See Ahmedabad Xavier Company, and also Atmaram also is important.
If we accept this argument,
Yes.
there are two difficulties.
Yes.
One is that the legislature, the contention is legislature deliberately did not confer on the courts the power to modify, which was earlier there in 1941. Which was there in 1941. Secondly, where do and how do we draw the line to modify?
Yes. My answer is you draw the line to modify. It is not a first appeal power under section 96 where you can reappreciate everything. That power to modify, the drawing, the line or the Lakshman Resha, so to speak, it has to be patently illegal. Once you take patent illegality, and which has been explained by the court in number of judgments.
Look, there's difficulty.
What?
Patent illegality, we set aside the award.
What?
Obviously, we don't re-adjudicate. We don't re-adjudicate.
No, that's what I'm saying.
Courts do not,
No.
because that's also part. Look, if we accept, we have the power to modify, then where does the court power end?
Yes. Where do you draw the line?
Where do
Can
you
you go
draw?
all the way, or do you draw a line? Where is this? Where is the question? My answer is the power.
And that's the difficulty when the legislature doesn't draw a line.
Yes.
It can be argued that the legislature never intended that power to be there.
Yes. But when I come to the end of after this submission, my submission is the Gayatri Balaswamy's case, which is now before your lordship. It first came before a single judge. And in that judgment, Justice Ramasubramanian, as he then was, he has given in 7 paragraphs why there is always a power to modify the award, even within the limitations of section 34. If your lordship sees that, and it's a constitution bench, it's a bench of 5 judges, your lordships are untrammeled by precedent. There is no judgment of a 5-judge on the issue of arbitral award modification. So lordships are not bound by any precedent. Your lordship can set the law, whichever way your lordship feels justice has to be done. But kindly see the reasoning of Justice Ramasubramanian. That may give some idea as to why we should read the power to modify by itself. And towards the end, I will say, just add 2 words in section 34A, add in 34.2A, add 2 words in 34.2B, and the problem is solved substantially, is my humble submission. First, let us go to Justice Ramasubramanian's judgment. Well, I've got hard copies also.
Can we have one?
Now, my lord, your lordship will just make a note. Lordship will just note in serial number in the list of cases. Lordship will just note Puri construction, Delhi High Court says no modification. Lordship will just make a note so that I don't.
Which I see a number.
In serial number 10, no modification. The Bombay High Court, full bench, gives a well-reasoned order why there is modification, why there should be modification.
Bombay High Court says full bench modification.
Modification. Now, please come to Gayatri Balaswamy's case.
Let me just note that is on partial set aside and not modification.
Correct. No, I am saying,
difference.
no, I am saying modification is equal to partial set aside can be modification also. That's my point. Why do you say the larger includes the lesser? I need not set aside 100%. I can set aside 18%, 20%.
So
whatever.
probably the other side is accepting there can be partial setting aside.
No, they don't.
If it is permissible, in view of how the award has been drafted. If the severability is possible, they accept it.
Suppose it is not severable, then what happens?
Then, no, there are issues there. Severability, probably both the sides are now at item that there would be no difficulty. Because you are supporting it, they are not opposed.
In fact, 34.2A also says so.
34.2A4. No,
also says
2A4 partially.
Exactly.
Partially. It cannot be said completely. It cannot be said like, let's take the example where they counterclaims and claims.
Or like we challenge.
Not because counterclaims and claims can be at times completely separate, but at times connected also.
Yes. Yes, you're also right.
And in fact, we have a case in which counterclaims have been rejected, claims have been now both were allowed, partially allowed,
Yes.
and balancing out equity or what is pronounced. The High Court says the counterclaim should not have been allowed because the long principle of law is applied by the arbitrator and patent illegality set aside. Now the irony is now in the law, the claims will stand on a different footing, counterclaims will stand on different, like they could have been 2 separate arbitrations also.
But a common arbitration award is passed.
There is a common arbitration. Now, under the award, amount will be payable under the claims.
Lord, my submission is, unless your lordship reads the power of modification in the sense, in the sense of modification.
Then you're going back to section 15. Limiting.
No, not necessary. I'm not saying going to that extent at all. I'm going to give the contours.
15 is restricted part, except in under clause.
Yes.
15 is a very restricted
No,
part.
I see 15 did not have the concept of patent illegality. 15 did not say don't appreciate evidence. 15 gave a complete open power to the courts to modify the award. I'm saying that ship has sailed. Nobody now says in arbitration regime you give that power. But look at where we have come now. Because of
3033 was far wider.
33, exactly. And as just look,
3033 was much wider.
when we were juniors, the person who files an application to make it into a decree, we will file an objection saying why the award is to be set aside under 3033. So there will be 2 OPs in Madras at least. And both the OPs will be taken up for hearing and there will be a common judgment.
Everywhere.
Yes. Same thing in Delhi, perhaps, yes. So now my lordship will see where we are faced now. It's very easy for us to debate academically, modify.
Okay,
if you don't have the power to modify.
Let's see the Madras High Court judgment.
Madras judgment, yes. Because we have now a situation where the government has issued a press note about 10 crore, no arbitration. I mean, can you imagine the third largest economy not having an arbitration provision? Very serious matter, my lord. We can't simply say set aside, no set aside. A person who has got an egregiously bad award, you can't simply say, sorry, we'll throw our hands up, you go back. Page 160. Please come to page 166. Yes. And my lord, the judgment starts at page 176. Now please come to page para 52. The learned judge put forth the question as to whether we have the power to arbitrate. Lordship will just come, my lord. It's a very, very well reasoned. Yes. Kindly come to para 39 at page 186. Yes, Lordship will kindly come to page 181 where the issues are framed by the learned single judge, as he then was. 181 bottom.
Yeah.
Para 23. Lordship, please come to page 181, para 23 at the bottom. May I read, my lord? Therefore,
Yes.
yes. Just see above para 23 in italics. Therefore, the pair in the present petition cannot strictly be construed as one for setting aside the arbitration award. It is actually for modification of the award in such manner as to allow those claims which were disallowed by the arbitrator. Therefore, two questions arise for consideration. They are: one, whether in a petition under section 34, this court is entitled to modify the award either by enhancing the amount awarded by the tribunal or by granting a relief that was rejected by the tribunal, especially in the light of the express language of section 34, and B, if the answer to the first question is in the affirmative, whether the petitioner is entitled to grant so and so. Now, my lord, kindly come to section 24. Then you please come to para 29, where he refers to section 15 of the Arbitration Act. And then from para 30, he discusses various cases. Lordship will kindly see para 29. Under section 15 of the Arbitration Act 1940, the court was conferred with the power to modify or correct the award.
There are two things. Where courts have done it, but without examining the power of the court.
Correct.
That will not help you. Where the courts have examined the contours of section
Yes.
34, those decisions will be helpful.
Correct. The lordship will discuss all that.
When we rely upon judgments of the Supreme Court in the High Court, and the Supreme Court has modified the award, then you can possibly say, because the Supreme Court has done it, therefore we have impliedly read that power into it, we need not examine it, we are even bound by the arbitrator.
I have given pre-Hakim,
There
there are two sets, my lord, where without examining or 142.
So even orbital data is binding on the High Court, so that we saw, we will not go into that question.
Yes. No, your lordship is right. Just because an award has been modified, that doesn't mean it's Article 141. It's a law which says you can modify. I appreciate that. But what the learned judge has done is, he has seen that, look, this is a problem, this is a vexed question, and then he deals with it. Kindly come to the, I'll just read para 29 and I'll
Dealt with McDermott,
pardon me?
examine McDermott.
McDermott also, it only says, now lordship will finally come after examining all the cases. And actually McDermott says you can't modify, but McDermott modifies.
Under 142.
Under 142. Then in Hakim also what happened is, Hakim was a case where the court modified the award. That was challenged. The court says you can't modify the award, but the conclusion is, under Article 136 we will not interfere. So you have approved the modification. Because in NHA,
That may be, these you can't rely as ratios.
No, I'm only saying.
Can't rely upon these judgments.
No, I'm saying in
Or
the case that the court
findings
recognizes that there is no power to modify, you still modify. Then that.
Yeah, we are not bound by arbitrator.
Correct,
As the
correct.
Supreme Court,
Absolutely.
we are not bound by arbitrator.
Because
We
it's
are
a
only
fight
bound by the
that-
ratio.
To use Justice Rajagopal Iyengar's word, you are untrammeled by precedents. Yes. Now kindly see, para 39 is the real conclusion. May I read, my lord? Para 39. Because, my lord, this matter we argued for several days in Madras.
You had the benefit of arguing.
Pardon me?
Yeah.
You had the benefit of arguing it.
Yeah, I argued with that. Yes. I never thought it will ultimately come with 5 judges. Yes. Therefore, from the various decisions of the Supreme Court and of the Bombay and Delhi High Courts, it is seen that the judicial trend appears to favor an interpretation that would read into Section 34 a power to modify or reverse or vary the award, except one observation found in the decision of the Supreme Court in McDermott. All decisions of the Supreme Court have either modified the award or approved the modification of the awards done by the courts under Section 34. At this stage, it may be useful to have a look at similar provisions so and so. Then his lordship takes the trouble of going through various foreign provisions up to Singapore. That goes on. Yes. What? Now please come to page 191. 191.
Yes.
Now please come to para 50. Keeping the above global scenario in mind, if we have to look at the language of Section 34 of the Act, it appears that the same also favors such an interpretation. Now, Lordship will kindly see just above that, his Lordship refers to Singapore, right? As if reiterate such a conclusion, Section 51, which has been applicable to both 48 and 49, speaks of varying an award under subsection 2 of 51. Therefore, Sections 47 and 51 to the Singapore Act make it amply clear that the power to set aside includes the power to vary the award. Keeping the above global scenario in mind, if we have to look at the language of Section 34(1) of the Act, it appears that the same also favors such an interpretation. I have already extracted 34(1). This is important. What 34(1) says is that recourse to a court against an arbitral award may be made only by an application for setting aside in accordance subsection 2 and 3. Therefore, Section 34(1) is obviously divided into two parts. The first part conferring a right and the latter indicating a remedy. If we perceive the first part of 34(1) as the soul and substance, then the second part of 34(1) is the form in which the remedy is to be worked out. The form or manner in which a remedy is to be sought can never curtail or limit the right which is made available under a statute. Now, here is also a case for reading Section 9 also, I'll come to that later, whether the powers of a civil court under Section 9 can be taken away by 34. Now, please see further. The expression recourse to a court under arbitral award is a comprehensive and inclusive expression. Merely because such recourse is to be made in the form of an application to set aside the award, it cannot be construed that the power of the court is limited by 34(1) only to set aside the parties and to leave the parties in a position much worse than what they contemplated or deserved before the commencement of the arbitral proceedings. A statute cannot be interpreted in such a manner as to make the remedy worse than the decease. A narrow interpretation of Section 34(1) would actually spell doom for the arbitration regime and create a mischief. Therefore, in my considered view, recourse to a court against an arbitral award appearing in Section 34(1) cannot be construed to mean only a right to seek setting aside the award. Recourse against an arbitral award could either be for setting aside or for modifying or for enhancing or varying or reversing an award. The application for setting such an award appearing in 34(2) and 3 merely prescribes the form in which the person can recourse against an arbitral award. The form in which the application has to be made cannot curtail the substantial right conferred by the statute. In other words, the right to have recourse to a court is a substantial right and not liable to be curtailed by the form in which the right has to be enforced, exercised. In my considered opinion.
How do you say that, Mr. Datta? Is it not too broad? Directly contrary to 2 and 3.
Yes. Now, my lord, I also realize one thing is that it's virtually like a Section 96 power. You're going all the way.
Section 9 says expressly or impliedly, unless it is expressly or impliedly barred. And these 2 and 3 operate as restrictions on the power, and they define the scope of the power.
Yes.
It's not a form prescribed, it is a substantive provision setting out parameters of
no, suppose the award is contrary to the public policy of India. Is setting aside the only remedy? Cannot the court modify it to, suppose it is out of sync or there's an aberration, can you not set it right? Now kindly see one other point.
Mr. Datta, that means two jurisdictions. Two jurisdiction exercise at the same time.
No.
One is jurisdiction under 34, the other is jurisdiction as a court, as a normal civil court.
No, now the point is this.
That may not be.
No, one more difficulty.
That will be very difficult.
No, one more difficulty.
Don't go by the extreme proposition. It will be very difficult.
Yes, I'm not going. I'm saying.
And therefore, it may not be if we
No, I'm
have to,
saying-
look,
True, I'm not going to that extent. I'm saying this judgment is.
that's virtually saying the court steps into the shoes of the arbitrator. That's not possible.
No, and one more thing is this judgment is.
Court is not an arbitral tribunal.
One more thing, the judgment is 2nd December 2014. The 2015 amendment introduced 34(2)(a) as to show to what extent interference can be there for domestic awards. So, but what the learned judge says is recourse to a court means recourse to a court mentioned in 2(e) of the Act.
That virtually says that then Order 41 principles will be applicable.
No, I'm not going to that extent. Now, my only submission is this, my lord, and I'll go to my submissions. I am only submitting that the power to set aside will always include a power to modify or vary to the extent it is necessary to make the award enforceable. Now, it can't be a binary. It can't be either you set it aside or don't set it aside. Now, if you say you can partially set it aside, what are we talking about? What do you mean by partially setting aside an award? Are we saying that there are 7 issues? And I'm setting aside the award insofar as issue 4 and 5 are concerned and upholding the rest? That's also partially setting aside. Or it could also be a situation. Kindly see, my lord, we are here to make an arbitration because the person must say, instead of going to a civil court, I'll go to arbitration. It is cheaper, faster, and
Not cheaper.
it is cheaper, my lord. It is cheaper. No, we only, your lordship will forget about Delhi arbitration. My lord, arbitration is not so expensive and and many arbitrations are not by retired judges also. Many arbitrations are by, like Bombay Stock Exchange. How many arbitrations take place which never come to court?
Bombay arbitration, that's a.
No, the stock exchange arbitration, the small arbitration.
Rule, regulation based.
Yes,
Statutory
I'm
and
saying there are a number of
regulation
cases.
Right, statutory and regulatory based arbitrations are different.
No, and I don't know about, at least in Madras Arbitration Center, so many small arbitrations are there. In fact,
That's good.
there was a proposal done by Justice A.P. Shah,
That's good.
where every senior counsel had to do 4 or 5 arbitrations pro bono, where the amount was less than 1 crore, 50 lakhs. All of us have done arbitration pro bono in our chambers. So that many cases are there. Not chambers 4 lakhs, 6 lakhs. It's not that these are all multi-crore arbitration. There are a large number of arbitrations which are quite small. I am only submitting, my lord. Let us test when you say partially modify. What are you partially set aside? What are you doing? I'm asking myself the question. Now, suppose I know. Let's say in one particular issue.
What you are doing is setting aside that part, but not modifying it.
I'm saying, I'm putting, why not modify it? I'll put a lordship. On issue number 4, the arbitral tribunal has passed a judgment which is directly in the teeth of a Supreme Court decision. Now, why can't the court under 34 say the Supreme Court has said A plus B is equal to C? The arbitration tribunal has erred by saying A plus B is equal to D. I need not set it aside. I can simply substitute C for D and continue with the award. Why not? Lordship mentioned about the cement part of it. Suppose he has wrongly taken 80 rupees per bag where the amount is 40. Why set it aside? Substitute it. I am only saying trust the judiciary, my lord. We all felt that if basic structure comes, everything can be challenged. It's only 4 times you have done it. Article 226, you got a wide power, but it is also with restraint. So I am submitting, why can't we say that if a particular issue in an arbitral award has gone completely wrong, it's out of track, why can't the High Court or the District Court under 34 put it right? And if the court goes wrong under 34...
May I request the person who was supporting the view modification or if you can assist us and help us.
Yes.
When will interference by a court will not be treated as modification? Modification, when will you not treat it as modification? When interfering with the interest not amount to will not be treated as modification? Clerical or arithmetical areas should not be treated as modification? Or there is something which is where
Small repairs. What the court says, they are small repairs, minor corrections. Will that be permissible? Lordship is right. We have to actually define what is modification. I'll only mention, Lordship asked the question, what is modification?
There's a reason why modification may not have been incorporated.
Yes.
Because if modification is incorporated without defining what is modification, as it was done in section 15, it will virtually mean that the court then sits into judgment and examines, after having set aside, it examines that. Now, the very fact that the court should not do that while examining 34, because 34 is a summary proceeding. In a way,
In a sense, yes, yes. It doesn't, it's not a section 96 CPC. That's very clear. Neither a section 100 CPC.
it's not like your original.
Yes. But can I suggest what I've suggested in the two, what words can be added? Lordship will see that makes sense. Because, I'll study it because what I was grappling with is, what do you mean by modification? Because it's, and as a Lordship knows.
Can we apply the principle that the basic structure cannot be changed,
Yes.
but you can.
You can give me those words, I'll pass it on to Parliament.
Which one?
Addition can take place there.
No, it has arisen in other jurisdictions.
Yes.
Here it's a rent control, very mundane for a big
Yes.
arbitration case. Material alteration. Repairs would not be material alteration.
Correct, correct.
So
Small repair, small little, just like small little repairs here and there, which really do not destroy the substance of the award, the substratum of the award, as long as it can fall
My
with.
lord, it would be with unguided, my lord,
That way.
word.
No, we understand that.
What
Just,
small
it's
and
just a
at
question.
what extent that smallness stops. That's all.
But Lordship will just take this. I have underlined it. Take this copy. I have said, Lord, I'm just trying to sort out a problem, and I'll work on modification also. Because my point is, when you say partially set aside, what do you mean? When you say modify, what do you mean? Lordship will just, I've underlined the modification which the court has done. I'm saying that the power of the court to add words is not known. Please take this. Pardon me.
Mr. Tushar Mehta, normally it's the government side which comes and says, please reduce the interest. Government side which normally comes and says, please reduce the interest. Most of the cases.
My lord,
From my experience, and I think
Lord-
all of us on this side will.
not only, my lord, interest, on the government side and PSU side, we mostly pray that please modify, and usually we say set aside. Because, anyway, my lord, I'll not go into it, but
Lord, can I
am assisting only on a proposition of law. I wish your lordship finds a way to get the power of modification, but I think, my lord, adding words may not be the correct.
Lord, what I've, Lordship has got page 1A, my Lord, first.
Yes.
1A, because that, I'll come to the landscape later. Please come to 1A first. What I've suggested is, in 132, 34, 24,
Okay, if the legislations which are brought, which permit modification, is there any restriction on modification?
no,
There's a blanket,
No, no.
the absolute,
pardon me?
there is no restriction or qualification for modification.
No, in 34,
Where modification is permitted in the foreign jurisdiction.
under 142.
Under the arbitration acts of those, arbitration laws of those countries.
Of 1940. No, I didn't follow. I didn't-
Foreign jurisdiction.
Apologies.
Foreign jurisdictions where the power of
Yes,
modification.
they say varies,
Is
let us
there
say
any
modify. Yeah,
restriction?
they say so, yes. They
It
vary.
only says
The
very.
contingencies in which it can be.
In fact, Ramsuranam has reproduced those
It,
sections.
my lord, I have given, my lord, about 14 to 15, where it is other than uncitral model, and thereafter I have given, my lord, another list in the.
We were interested where the power of modification, say in Singapore or in,
Expressly mentioned modified.
yes.
We'll get-
But
And
is
give
it
contingent-
hedged with conditions?
Conditions also that it can be modified, varied, on if following is present. It's not uncanalized.
It's
so to
not,
say.
it's not blanket power.
It's not blanket.
Lord, one suggestion I made, Lordship may kindly see. Please come to my note page 1A. Now come to B, 32 2B. I am requesting the court to add the words
38 of my submissions reproduces the jurisdictions where there is a specific power of modification with contingencies in which it can be done. 1-8,
You also read some of those provisions.
yes, 1-8 to 38.
Yeah.
Yes, but I read.
UK.
No, but
Right.
we didn't read out the conditions which are there.
Yes, my lord, please, my lord, have a look at, just by way of an illustration. Lord, page 22, this is United States of America. Section 11, your lordship gets, my lord? My lord, Justice Viswanathan.
Page 18.
Yes, section, page 22.
22.
22. I'm just giving an illustration. This is USA, same modification or correction grounds order. In either of the following cases, the United States Court in and for district wherein the award was made may make an order modifying or correcting the award upon the application of any party to the arbitration where there was an evident material miscalculation of figures or an evident material mistake in the description of the person, thing or property referred, where the arbitrators have awarded upon a matter not submitted to them, unless it is a matter not affecting the merits of the decision upon the matter submitted, where the award is imperfect in any matter or form, not affecting the merits. My lord, UK, my lord, if your lordship sees, which I read, my lord, page 19, substantive jurisdiction, I'm sorry.
Where the award is imperfect in form, not affecting the merits of the controversy.
Correct. My lord, please see 19 is more closer, my lord, to your lordship's query. 19, page 19, that is UK. My lord, first it defines what is substantive jurisdiction. My lord, page 18 bottom, competence of tribunal to rule in its own jurisdiction. Unless otherwise agreed by the parties, the arbitral tribunal may rule on its own substantive jurisdiction. That is, whether there is a valid arbitration agreement, whether the tribunal is properly constituted, and what matters have been submitted to arbitration in accordance with the arbitration agreement. Now, if we challenge, if I challenge it on that ground, substantive jurisdiction, then, my lord, section 67 applies, subsection 3.
This is with regard to the, you see, now this is very specific. Here, the power of the tribunal or the High Court or the court in the 34 in India is also very wide. In India, under 34, it's very wide.
Correct, but here that is, my lord,
Because that's a full substantive review. It's not confined to arbitral review.
no, correct. My lord, point is different. Subsection 3.
So
On an
subsection 3 will only apply to
substantive jurisdiction.
or substantive jurisdiction is only relating to the existence of arbitration agreement, constitution of the arbitral tribunal in accordance with that
And what
agreement,
matters have been submitted.
and the matters covered by. So in that case, there is no difficulty.
Lord, please
There we can do it. There, let us put it, we can do it.
No, please see 69. Page 20. Appeal on point of law.
Yes.
But same arbitral award can be subjected to appeal on point of law. And please come to page 21, subsection 7. On an appeal under this section, the court may by order confirm the award, vary the award, remit the award, set aside the award. Because it's an appeal. The statutory intention is to provide for an appeal if it is an appeal on a question of law.
My lord, one thing is, if your lordship sees 34 to 1 to 3, 1, 2, 3 and 5 are tick box. Yes or no? There is nothing to be discussed. Agreement not there, party incapacity, and 4 is composition is bad.
Let's give another, not case specific. Let's give there are two clauses. One clause says so much amount will be payable. The second clause says this amount plus this amount will be payable. The arbitrator, therefore increasing the amount. The arbitrator holds this clause will apply. A plus B will be payable. The court holds it's patently illegal. In fact, the other clause is applicable. Can the court not give it,
Can the court not?
give the lesser amount? Answer will be no, in case we say we can't verify or modify the order.
That's the intention, Manu. That's the legislature.
But the,
It
but the-
should,
My lord,
it
again,
should have the power, but it does not have the power. That's,
whatever it is,
Our-
we
our-
follow-
our- yes.
rule of law means that we follow the power.
yes.
my lord, again, one possible view could be that if the arbitral tribunal was entitled to take a possible view, merely because this court thinks another better view is there, this court.
No, we are not going by that. I said, subject to the condition, this court finds is patent illegality. This clause is applicable, in fact.
Yeah, very well. Lordship is right. Suppose, for example, a clause is applied to situation X where it was never intended to be applied. And court can say, all right, you applied this wrong clause to the extent you applied it to situation X, I'm setting it aside. Perfectly fine. But suppose I'm giving a further example, Mala. What I'm submitting is, as far as modification is concerned, the difficulty is going to be where do we draw the line?
Yes.
I'm just giving the suggestion so that by next week we can also think about it. Kindly see, as far as 1A is concerned, I'm saying a lordship can add the word and to the extent, meaning that under 34(2)(b), if what are the grounds on which the court finds, what does the unicitral model say? Please see very carefully. 34(2) has two parts. It has clause A and clause B. What is clause A? Clause A is a party making the application must establish. So the burden of proof is on the party making the application. That's what the unicitral model says. Whereas B, the court finds. Even if the party making the application is not there, but if the court finds, once the award is before the court, if the court finds that the arbitral award is in conflict with the public policy of that state, it can set it aside. So the unicitral model makes it very clear. There are two classes of grounds. One is a ground where the party must apply and make good its submissions. And the other is a power reserve.
You added the words to the extent.
Yes, I'm putting in italics. I'm suggesting that.
But that will make another problem.
No, I'm just giving suggestions. We'll think about it.
In B, probably somebody can argue even when application is not filed, you can still invoke it.
Pardon me?
In B,
No. What I'm submitting is,
B, you can still argue if application is not filed under one, you can still argue.
no, there's no question of the court so motive. What the United Nations says is, if an arbitral award comes for enforcement,
If the court finds.
no, Lordship will kindly see. Yes. Maybe set by the court only if the party making the application establishes. Now, B, I'm saying, and to the extent the court finds. I'm saying because under A, there is no partial set aside. Under 34(2), there is no partial set aside. Only in 34(2)(a)(4), there is a partial set aside on severability. If some grounds can be set aside, can be severed, they can be set aside. Please see the proviso to 34.
To that extent, probably that item, that even we can extend it, even if not covered fully by.
Yeah,
But as long as severability is not, does not destroy the award itself.
award itself. So I'm putting that. Now, the more important amendment is in 2A because today the major practical problem is in domestic arbitration. And please see 34(2)(a). I've given two suggestions.
He says important amendment.
Yes, I'm
Can't
saying.
be amended.
No, I've got cases where Supreme Court has done it. I'm something saying. Lordship will kindly see. First suggestion, and I've got a second suggestion at the bottom. An arbitral award arising out of arbitrations other than international commercial arbitrations may also be set aside. Now, I've added the words wholly or partially, or modified by the court to the extent the award is vitiated by patent illegality. Why I'm saying is, this will enable partial set aside of the award and also, sorry.
Want us to treat it as a casus omissus?
Casus omission, when can it be provided by the court?
No,
When the plain reading leads to an absurdity, only in such an event the court can
I'm
supply casus
I'm
omission.
saying plain reading is giving absurdity.
May not be patently illegal. An award of 18% interest when the court feels 12 will be appropriate.
Yes.
May not be patently illegal.
Then it can't be set aside. It can't be modified.
Amendment won't take.
No, I'm only saying one you can set aside. Now we are all agreed that set aside includes partial set aside. All right. Now we still not define what is the meaning of partially setting
So
aside.
you will have to first, this can be the alternate argument. First is already encompassed in 34.
Yes,
One, locate the
Yes.
power
yes,
in the existing statute.
yes.
So this is a huge amendment exercise.
Which I'm giving 8 examples in my chart. Kindly see my chart. I know what I'm saying, but I know that I'm not asking you to judicially legislate. I'm saying make section 34 workable. 8 Supreme Court judgment, they've added the words. Now please see the first judgment, Gujarat Urja Vikas Nigam. Section 174 and 175 of the Act were completely incompatible. What does the Supreme Court do? Please see words added by the court. Addition of the following words, end of section 175, except where there is a conflict express or implied between a provision on this Act and any other law. So many words were added. And what's the reason given by the Supreme Court? If the words mentioned are not added to section 175, it will result in an irreconcilable conflict between 74 and 175.
So therefore, in order to make the statute workable,
Yes.
let us provide it, but here, such is not the position.
Section 34 is unworkable because you're only setting aside the what. What my point is, despite the amendment in 2015, huge problem in arbitration. If the award is horribly wrong also, court will say, I can't do anything. I can only set it aside. I can't give any relief.
No, these are head-on conflict cases. You see the last reasoning.
I'm saying, no, not necessarily.
Yeah, 174,
No,
175.
I'm saying what I'm submitting is there is a power to modify. Then your lordship may decide whether you want to do it or you feel it's not necessary. I'm saying that I'm not not putting a US amendment into this. I'm not putting a Singapore amendment. I'm not saying varying modified. Now, what is modified? Puranmal Lakhanpal, Article 370. Supreme Court says modify in the dictionary means minor changes. But they say in the context of Article 370, modify gives the president widest possible powers. It can be complete change. I'm not going to that extent of Puranmal Lakhanpal because I'm not under Article 370. I'm saying, Lord, we have to solve the problems. We are not here for any, it's not a seminar, Lord. We have to, how do we make arbitration work in India? That's my problem. When I give my Gayatri Balsami's case or Daras Kambata's case, majority award is gone completely wrong. Minority is there. Good. Supreme Court in Sangyong.
We have more severe cases, my lord.
Exactly.
We have lost cases where it requires a special brilliance to lose it, my lord. I have demonstrated that brilliance.
So that's why you should have sat here at the beginning. I was telling my friend not to go there, my lord.
My learned solicitor has not gone there. He has not read the last few paras of his submissions to your lordship. I'll be placing them, my lord.
In fact, government supports modification.
He's given a good submission.
Yes, he has given both the sides, but he's given both the sides, but he pointed out the difficulty in case we give the power of amendment or modification to an award to the courts. It may be then virtually we step into the shoes of the arbitral tribunal, which may not be.
That should not be.
No, that should not be done. But what I'm saying is, there's a practical difficulty. Where do you draw the line?
That's the problem.
One problem is wholly set aside is not a solution. Partially set aside is a partial solution. Can we go one step further and say, when you say partially set aside, what do you do? Can the court simply says, oh, this is wrong, I'm partially setting it aside. Why can't the court come and say, look, this is completely wrong. Supreme Court says A plus B is equal to C. I'll make it C, continue the award. Otherwise, only for that, he has to go back to the tribunals, argue that point again.
I'll tell you very frankly, if the court is careful in that,
Sorry, ma'am.
careful while setting aside the award,
Yes.
and they clarify the situation, parties are then aware that if they go back for arbitration, this is going to be our fate. If they're careful, if the court is also careful and the parties are also guided well by the advocate.
Lord, I don't know which way your lordship will solve the problem, but it requires a solution at your lordship's hands. How your lordship is going to do it, we'll have to deliberate and think about. I gave examples. Now please see the other sections where the court has said, and not just casus omissus, the lordship rightly put it, and casus omissus from the beginning they say courts can't supply the words. But casus omissus comes where the court has deliberately, parliament has decided not to include it. I've already shown the intention of adding 34 was with modification. There was no modification till 2016. Now, if you can set aside the award on the ground of patent illegality, why can't you modify the award to the extent of the illegality? Remove that illegality alone.
No, the other angle would be the legislature, parliament has amended it on 2 occasions, 2015 and 2019.
Yes.
So
that gives a clue.
So even after those 2 amendments,
Yes.
this provision has not been amended by the parliament.
It is when they propose. 2020.
Yes. No, what I'm submitting is, I take a cue from what your lordship said. 2015 Parliament realized if the award suffers from patent illegality, judicial interference is called for. Is that actually okay? Now, what is the error? What is the defect? Patent illegality. What is the cure? Set aside the award. I'm saying if the problem is patent illegality, is setting aside the only cure? Can we not judicially craft a way where the patent illegality can be cured, but the parties are not relegated to a fresh award all over again? That's what a lordship is saying.
The powers of the tribunal itself.
Pardon me?
The powers of the tribunal will
With
be
great
served.
difficulty, 34.4, no, 34.4 is only for ground for setting aside the award. Now, ground for setting aside the award, patent illegality, you go and tell the arbitral tribunal, this is patently illegal, you rectify it. Suppose he still says no.
No, suppose evidence is required, what do you do?
Pardon me?
Suppose evidence has to be taken.
Yes. Then you can't. Then you can't. Then you have to set this aside. Now, see, suppose, for example,
That's what my learner.
I'm giving an example. Suppose the arbitral tribunal refuses cross-examination. Refuses cross-examination, violation of natural justice. You have to set aside the award and send it back. Then there is no question. Lordship is right.
But that will come in clause 3 then.
Which one?
That would come in clause 3.
Otherwise unable to present the case.
Unable. No, there are many reasons. I'm just saying, what I'm submitting is there are cases where setting aside is the only way out. Like Justice Venkatramaya says, when you quash in certiorari, what do? You put it out of existence. Like when your lordship allows the appeal and sets aside, what happens? The judgment is not there. Your lordship's judgment is in virgin. So you may decide this award has to be set aside. It has to be quashed. No problem. But apart from setting aside, I'm only saying what is partially set aside, nobody is able to define. We'll have to find some answer to that is my problem. And kindly see some of the amendments, my lord. How the courts have judicially crafted it. And what Lord Denning says, that if I come across a section which Parliament never intended, I will not throw up my hands. I will be constructive and try to add words to it. That's a hot water case. I'll come to it.
Lord Denning also said that we can iron out the creases without
Yes,
altering the material.
Exactly. I'm saying this is, I'm C4 court estates. I'm only saying that I was about to say, I put in my note, what I'm suggesting is
But Lord
ironing out the crease and not
Denning,
altering the fabric. I'm not saying, I don't go to say that you can modify beyond patent illegality. No. If there is a patent illegality, that is a jurisdictional fact. There must be patent illegality. Then what? What does the 34 code do? Set aside.
Coming to the end of today's hearing, we'll have it on Tuesday. But try and finish it off on Tuesday.
I'll just take.
Just check up if there are any
Lordship,
foreign
Lordship
jurisdiction
is saying something,
decisions.
you have to look up on modification, so we'll make a
Yes.
note of it.
Just check up if you have any foreign jurisdiction decisions specifically saying, what do you mean by modification of an award? What
We
can
shall-
the do?
we shall.
What can the court do? What are the parameters under which the court can modify? Because the rulings or the provisions of law, as far as the statutory provision, the power of modification is not absolute. There's one thing is very
But
clear,
one-
even where it is concerned.
One Puranmal Lakhanmal's case.
Only
it says
one.
The word
request,
modify in the dictionary will
Instead
not
of
apply to
Tuesday,
law.
can it be Thursday?
Let it be,
No, there are.
let it be Tuesday with, no, we let's continue. The other side has to continue.
Yes, my lord. I am also reliable. My lord, thereafter jumped several issues, my lord, but in our rejoinder, we'll assist you.
Lordship will just see this chart also in the.